Call this second day of the August meeting of the Tennessee Real Estate Commission back into session. Just want to remind all you attendees out there, make sure your phones are on silent. And I think at this time, I turn the proceedings over to you, Ms. Ryan.
Okay. I will take them. This matter that we are here on today is an issue of summary suspension, and let me read into the record and for your information the laws concerning summary suspension. This is found in 45320. As you already know,
Sorry, Robin.
4-5-320, Tennessee Code annotated. As you already know, a license is a property right in Tennessee. These professional licenses are considered property rights, and therefore certain due process rights attach before we can, as a state, take actions against someone who has a property right. In this particular section, this is 45320, this is concerning proceedings affecting licensees. Section C states, no revocation, suspension, or withdrawal of any license is lawful unless, prior to the institution of agency proceedings, the agency gives notice by mail to the licensee of the facts or conduct that warrant the intended action, and the licensee was given an opportunity to show compliance with all lawful requirements for the retention of the license. If the agency finds that public health, safety, or welfare imperatively requires emergency action and incorporates a finding to that effect in its order, summary suspension of a license may be ordered pending proceedings for revocation or other action. These proceedings shall be promptly instituted and determined. Now, there are two ways to go forward with the summary suspension, and they are embodied in Section D. 1. Notwithstanding the provisions of subsection C, in issuing an order of summary suspension of a license, the agency shall use one of the following procedures. A. The agency shall issue a notice of the licensee providing an opportunity for a prompt informal hearing, review, or conference before the agency prior to the issuance of an order of summary suspension. Or B. The agency shall proceed with the summary suspension and notify the licensee of the opportunity for informal hearing, review, or conference before the agency within 7 business days of the issuance of the order of summary suspension. In this particular instance, we have gone forward with A. We have given a notice to the licensee and given that licensee an opportunity for a prompt informal conference or hearing before you all before any issuance of a summary suspension. Please remember that a summary suspension is only appropriate when this body finds that the public health, safety, or welfare imperatively requires an emergency action. That is the only time it's appropriate. Having said that, we are here today on the matter of Gary M. Griffey and Griffey and Associates. We have a letter that was sent to Mr. Griffey based on 4 complaints that we have in front of us. We'll tell this commission there's another complaint that's not been reviewed. But in essence, the allegations in these complaints are as follows, and I will read them to you. In one complaint, Gary M. Griffey and Griffey and Associates Incorporated have served as property managers for a property owned by complainants Andrew and Dolly Toussaint, I think is how you pronounce their name. Complainants have not received rental deposits from Gary M. Griffey and Griffey and Associates for the months of August 2012 through February of 2013. These complainants were sent 3 checks from Griffey and Associates Incorporated, which were returned for insufficient funds, namely, check number 3814 dated December 13, 2012, written for the amount of $1,680.94 was returned for insufficient funds. Check number 3946 dated January 28, 2013, written for the amount of $3,403.08 returned for insufficient funds. Check number 3950 dated February 4, 2013, written for the amount of $2,890.94 returned for insufficient funds. In the response to this complaint, Mr. Griffey admitted that the current amount owed to the complainants was $4,663.08. In the second complaint, Gary Griffey and Griffey & Associates Incorporated are the property managers for a property owned by complainant Sean Wild. This complainant had not received a payment from Gary M. Griffey and Griffey & Associates since March 2012. Complainant states that in January 2013, complainant noticed that no deposits had been received. Gary M. Griffey admitted in the response to the complainant, and this response was dated April 3, 2013, that the outstanding amount owed to complainant is $7,346, but this stated this was due to problems with complainant's bank. The complainant states that the complainant verified with his bank that the bank has not received a check from Mr. Gary Griffey and Griffey & Associates since March of 2012. The complainant states that the complainant believes that the complainant is owed $10,260, which equals the amount of rent for 12 months since no statements of expenses have been provided to the complainant. Complaint number 3. Gary M. Griffey and Griffey & Associates are the property managers for a property owned by a complainant named Mary Reagan Kohler. Ms. Kohler states that Griffey & Associates wrote bad checks to complainant for every month's rent in the year 2012, resulting in the closure of complainant's bank account. Complainant's attorney, Noel Bagwell, provided a transaction list from the current tenant at complainant's property, which shows all payments received by Gary M. Griffey and Griffey & Associates Incorporated by the tenant for the period of occupancy from March 2012 through July 2013. According to complainant's attorney, complainant has received no rent proceeds from Griffey and Griffey & Associates for the months of January 2013 through July 2013. 2 checks were sent to complainant's daughter but were lost, which resulted in a request for stop payments and reissuance, which complainant's attorney states has not been done. According to the complainant's attorney, and based on the conversations the attorney had with Gary M. Griffey and Griffey & Associates, they do not use an escrow account. Complainant's attorneys understands that Gary M. Griffey recently suffered a stroke. The Tennessee Real Estate Commission has received no indication that Griffey & Associates has obtained a new principal broker. Complaint number 4. Gary M. Griffey and Griffey & Associates are the property managers for a number of properties owned by complainant Amy Daschel. Please forgive me if I pronounce the names wrong. Complainant was sent multiple checks for the rental amounts obtained from the month of February 2013, which were returned for insufficient funds twice, and which Gary M. Griffey and Griffey & Associates Incorporated have not fully refunded complainant for this payment. Complainant also states that Gary M. Griffey and Griffey & Associates Incorporated have failed to remit money owed to complainant for the months of February and March of 2013. Complainant states that Gary M. Griffey and Griffey & Associates wrote a tenant's security deposit check to complainant's new management company, which was returned for insufficient funds and has not been corrected. Complainant states that when complainant has contacted Gary M. Griffey and Griffey & Associates Incorporated about the money owed to complainant, complainant has been told that there are not sufficient funds in Griffey & Associates Incorporated's bank account to reimburse complainant. Neither Gary M. Griffey nor anyone on behalf of Griffey & Associates submitted a response to this particular complaint filed with the Commission. Furthermore, Gary M. Griffey's license was suspended for a period of 12 months pursuant to a consent order authorized by this Commission, and information within the complaints indicated that Mr. Griffey was performing real estate activities without an active license during that time period. Complainant Wild first noted there were missing deposits in June 2012, prompting complainant Wild to contact Gary M. Griffey and Griffey Associates by email, after which complainant Wild states that he spoke with Mr. Griffey, who assured him that the situation will be corrected. Said incident had taken during the time that Gary M. Griffey's license was suspended. During the time that Mr. Griffey's license was suspended for 12 months pursuant to that consent order, the firm Griffey & Associates went through a period during which there was no principal broker of record. Considering all of these facts is the reason that we brought this matter before this Commission this morning. You should know that the most recent complaint and the most recent allegations of failure of funds to be paid and or insufficient checks were for July of this year, and all the other ones were from much earlier this year or of last year, but are in the complaints that are before you today. At this point, it is up to this Commission to determine and decide things, but the respondent is being represented here by Mr. Tim Harvey, who is in the position to speak on behalf of his client and answer questions or present whatever he wishes to present.
Commissioner Grease.
To either attorney, where are we trying to get today? To either say this guy is dangerous to the public and we need to...
The standard is, as I said earlier, that if there is a finding that immediate action must be taken due to the public health, safety, or welfare of the public, then that immediate action we're asking for is a summary suspension. If a summary suspension is granted by this body, then the next action will be a formal hearing as quickly and promptly as we can to address the issue head-on.
So are you making the request?
I am bringing this to you for your decision.
So there's no staff recommendation?
I'm bringing this to you for your position.
I'll take that as a no, then thank you.
And if, Mr. Harvey?
Good morning. It popped on. I didn't know if I was supposed to punch a button here or not.
You just talk and it's voice activated.
Okay. Good morning, and I appreciate the opportunity to be here. I'm Tim Harvey from Clarksville. Had to bypass a wreck and take some detours, but I got here on time, and I'm happy to be before you, and I appreciate your time. Thank you very much. Mr. Griffey is not here today. I want to be careful and tell you what I know out of my mouth to be accurate, and what I am telling you about Mr. Griffey's situation through his comments to me that are current. I sent several pieces of correspondence with the staff here today, principally Ms. Ryan, talking about trying to appear here today, talking about trying to reschedule that to a different time and have Mr. Griffey here, because I can tell you that yesterday when I talked to him about not being able to reschedule this hearing, he returned the call through his wife, who was with him at Gateway Medical Center, according to her, having some tests done. He's supposed to be at Vanderbilt for some tests done today. That's what I'm told about Mr. Griffey. Similar to the comment in here about he may have suffered a stroke somewhere along the way. I've been told that. I understand he's having medical testing done from Mr. Griffey talking with me. Number two, I can tell you some things that I know from Mr. Griffey's representations to me. Mr. Griffey and Griffey & Associates, LLC, operates a real estate office which includes a fairly large property management group. There are several large property managers in Clarksville, and he was one of them. He became aware from complaints that his accounts were not balancing, which is obvious if any of the factual information is true, apparently some of which he's admitted instance by instance. He named me, and I have been fielding phone calls from people who have any concern, and Mr. Griffey has told me that they have attempted to reconcile all of their accounts and to tell me, for example, in the case of Mr. Wild, who I've talked with 3 or 4 times, one of the complaining parties, and who I saw in my office yesterday afternoon, Griffey & Associates, at least by their accounting, acknowledges they're in arrears to you for X amount of money through the month of June. And they don't intend to make any mistakes about accounting for receipts and disbursements from the end of June forward. I respectfully suggest that some complaints about not receiving money in July could be associated with reconciling the June numbers that come in. I'm told we'll be reconciled and correct on any receipts we make after June 30th. But as of June 30th, I've got a list of people we think we're in arrears to. Again, for example, Mr. Wild is one of them. I've acknowledged to Mr. Wild that at least this is what we think you're entitled to, what you're owed, as through the date of June. We are trying to marshal and liquidate assets of Griffey & Associates, LLC, to see what funds are available to pay you and anyone else we owe. And I make a representation to them that they should contact an attorney, talk with an attorney, get their own representation. But I can't represent how much money Griffey & Associates will have or when they have it. But I can at least tell them, do what you want to do, but we will acknowledge we owe you this much money in the list of persons I have. I understand the nature of this emergency hearing is to protect the general welfare of persons who might be harmed by his continued operation. I can tell you now that his plan is to do through me, I'm telling you, his representation to me is, let's try to do everything we can, figure out who we owe, what we owe. Let's try to figure out what kind of assets we have. Let's try to get those liquid, and I'm told he's already listed some commercial property that's in Griffey and Associates' name. And let's try to get some money together and see how much money we have and see where we reconciled our books, and let's try to see what we can pay these folks on the ones that we know we've got acknowledged arrearage to. So Griffey and Associates is open and answering the phone, but most of our activities, if not all, and again, I can't make a representation exactly, I'm not there, I don't work there, but I'd imagine most of the time our phone rings, it's people who are concerned about what we're going to do about this rather than opening up and operating new business. And I am retained to help them try to figure out what we owe in arrearages and try to figure out what funds can be made available at some point in time to pay those amounts. So I'm not really certain that I'm not really certain I know all the full scope of what we would be precluded from doing if you grant a summary suspension. I can assure you that my directive will be to recognize the power of this board, and if you summarily suspend us and we can't answer the phone, then we won't even answer the phone. But I can tell you my representation is Mr. Griffey has told me we're answering the phone to try to answer questions, and we're sending them all to you, Tim, and I'm telling them this is a number we have for you. I can tell you I have talked to people over the phone who represented to me. I've talked to Mr. Bagwell, who represents Ms. Quarles. Ms. Kohler. I've talked, there are 2 or 3 general session suits that have been filed, one by Daschle, who I believe is represented by Larry Riccone, one by Quarles, who I believe is represented by Ray Runyon. I have talked with a Mr. Donaldson. I have talked with a Mr. Weiss. I have talked with a Mr. Connie Lane. I have talked with a Mr. Lucas. I've talked with a Mr. Ruerts. I've talked with a Mr. Nebold. I've talked with Mr. Martinez. There is a lawsuit filed by Ms. Fennell, and I have talked with her attorney. As a matter of fact, I may have one of those names mixed up. Mr. Runyon may represent her as opposed to Quarles, but I've also talked to Mr. Wild. I have made the representation to those folks that it looks like we have some arrearage owed to you through June. If you want to hire a lawyer and you want to pursue that, go ahead, please do. But on behalf of Griffey, I can tell you that my client tells me we're liquidating assets and trying to find out if there's money available to pay acknowledged arrearage. My hopes today, frankly, are to receive from you some sort of controlled directive that if we carry that out, you don't perceive that as harm to the public or future harm to the public, and maybe we will be able to, instead of me getting 14 or 15 other lawsuits and having attorneys' fees which just deplete their funds, try to tell these people as they make these claims, this is what we're going to do. Just like Tuesday follows Monday, some of these people have said, you owe us money, we're declaring you in breach of the contract, we're sending our property somewhere else. That's occurring in a lot of these cases, almost all of them. So it's not as if further harm occurs that there's ongoing arrearage. It's still unfortunate. That doesn't make it all right. But I'm suggesting in terms of further harm that most of these folks have gradually moved to other locations. And I can tell you that there are many, many fine other reputable property managers in Clarksville. Some of you may know them. Clarksville has an abundance of rental property that is managed through out-of-town owners, primarily associated with the military. And we are talking with one of those property managers who's been in the business a long time about his coming in, examining our books, taking this over, and going through the process of transferring any contracts we have open to him so that these people are managed by him instead of us, and so that these people can stay with him if they want to, or obviously move on, in order to just try to get the books running like they should be running. So My purpose is to tell you, Mr. Griffey is telling me and identifying the names of doctors and locations that he has a fairly significant health problem. We respect how nice it is to have a real estate license and the duties to have a real estate license that go along with it, so it's not a who cares attitude. But at the end of the day, we probably aren't going to try to preserve Griffey and Associates Incorporated any longer than necessary, or in any way more than necessary, to try to figure out how we can pay the debts of Griffey and Associates LLC. Thank you.
Mr. Harvey, do you know how many properties Mr. Griffey is still currently managing?
No, ma'am, but I think it's very few. I realize that's a subjective comment. I would say maybe 20 or 25, and of those that he's still managing, we may be in the process of telling those folks that there's an arrearage, or acknowledging that arrearage as they complain, and trying to develop some sort of agreement on this is what we owe you, and just inform them of what's going on. I can tell you that I'm not the person who's reconciled his account. I'm not the person who has come up with these numbers, so I can't verify anything about them. But I can tell you that what they have indicated to me they've done is they've caught their books up through the end of June. So if a renter was still there and Griffey was still managing the property, the renter's income the rental payment would come in June. It would wash through a proper accounting cycle, and then it would be remitted of net proceeds back to the owner of the property. So as of June, we think we know what we believe is arrearage. As of July, I'm not sure how many properties they have, but I don't think, if I could suggest to you that 50 is a breaking point, I think it's far less than 50. I don't think we're talking about 100 or 200 or...
Ms. Maxwell, does he have any other principal brokers in his firm? I mean, any other brokers? I'm sorry.
He has one other broker who is actually a licensed broker, or at least our records indicate that he does have one other person, and the only other person that he has in his firm is a broker, and his name is Philip Provo, and I don't know if you're familiar with him or not, but anyway, we have him listed at that firm.
I do not know him. Just so you'll...
Ms. Ryan, would an appropriate action of this commission be that if we suspend Mr. Griffey's license, to recommend that Mr. Provo be put in as principal broker?
You can make that recommendation, but the issue you really are only seeing is whether or not the summary suspension, I mean, that would be the only order that would come down today, and that you'd also be suspending the business as well, Griffey and Associates, unless you determine not to suspend the business and just suspend the individual license. But there are two licenses before you this morning.
Hang on just a second. If we suspend Mr. Griffey but not the firm, would that allow them more leeway to correct this mess?
If there's a principal broker in place that would allow the firm to continue, then I would think it would. But again, that does not mean that it will happen. It does mean, though, that the business would still be in business, and if the appropriate person were in place, maybe.
Thank you.
Is he a current good standing with the Tennessee Real Estate Commission, and does he have E&O? And has he paid any fines he may owe?
He has, yes, he's paid the fines he's owed.
Pardon?
Yes, he's paid any penalties that he's been assessed. His license is set to expire on, Mr. Griffey's license is 7/30 of 2014. Griffey and Associates license is to expire on 3/30 of 15. And he has E&O. And one more point. I wanted to tell you that Ms. Crop did indicate that while they say that the phone is being answered and that may be a new thing, I don't know. But on July 24th, the phone was not being answered. And it may be something that has changed since then, but I wanted you to didn't have that piece of information as well, because Ms. Crop attempted to call both Griffey and Associates and Mr. Griffey directly.
Mr. Harvey, I have two questions.
Sir.
As the counsel for Mr. Griffey, and as you've been trying to assess how much is in arrears, do you have any idea approximately how much money Mr. Griffey owes to people who own the property that he was managing?
Yes, but I want to caution you that these are not my figures. I didn't make these computations.
I mean, just roughly.
There are some claims that are filed and in suit. I hoped to have made that clear to you. And there are some claims that I haven't talked to these people about yet, that we have on a list, which it looks like totals about $200,000.
The second question I have, and based on information that Mrs. Ryan read in the beginning of this matter, checks were bouncing and insufficient funds of checks that have been given to the property owners of the properties that he was managing. Do you have any idea what happened to this money?
No, sir. You know, it's again, I emphasize that there are a couple of claims that are filed, and I don't think that Griffey and Associates Accounting would agree that as much money as it is owed necessarily after we've reconciled those books. So if someone says, you owe us $10,000 and we want our attorney's fees and we want interest and we want penalty, that's a number than us saying we know we owe you $7,300. And again, I think I wanted to be candid with you. I think $200,000 is way up on the high side, and that deals with a claim that someone makes. And I think some of these claims probably aren't. The gross number of what someone claims may not really be what Griffey owes. But again, the way I understand the emergency nature of what we're here on today, and I'm not here to tell anyone what powers you have. I mean, I've told you though that at least my representations that I'm telling people, we acknowledge we owe you some money, and I do believe that my client he's certainly been advised and talked with me about liquidating assets and finding an orderly way to transfer this business, whether it's $80,000 or $180,000. Hopefully he'll be able to find assets to pay the arrearage that these people have, and his position would be that he was having some health problems and he was in denial over health problems, and that this is how this happened, and here's how the bookkeeping mistake occurred. But today, it's hard to kind of try all those issues. I think I'm really trying to keep us based on that emergency nature of what's best to protect the public. If I could make some comment about Commissioner Collins' comment about finding Mr. Provo to work on managing this. And
That wasn't me.
Oh, that was this commissioner? Okay. I haven't met with him and I haven't talked with him, and I don't know his status. We're talking with another property manager who is in a different group, who I believe is in good standing, and I can tell you that my hopes would be this board would govern us with the idea that we're going to try to do a couple of things so we don't breach any duty we have on how we move forward, but try to get some opportunity to amass funds, agree on what we owe folks, and see if we can get them paid. And that includes if we can find a property manager who would even consider purchasing the book of business as it may now exist. That's just more of an asset for Griffey and Associates to recoup money to have to pay people.
Mr. Harvey, how long has Griffey and Associates been in business?
I moved to Clarksville in 1983, and I've driven past their office for 30 years. Other than that, I don't know who was there, or I think his family had that business as a predecessor, and he's a son or a grandson. But candidly, it's been in continuous operation, but at the same location there on Madison Street, to my knowledge. But that's really all I know is anecdotal information.
So, Eve, Was there like a point in time when these complaints started showing up, or has it been consistent over several years? Do you have a sense of any history on complaints?
May I address that, Judge?
Absolutely.
Thank you. And Julie went to get it. As I said earlier, his license was suspended in 2011, and he did sign a consent order for a payable of $5,000. My understanding is, and I don't have the order, it was for issues and problems with the accounts, but I don't know for sure, and she went to get that, so you'd have that information. These complaints were opened in 2013, the ones that are before you. The most recent one was opened in July. The other ones were opened earlier this year. They address in the complaints, as you heard earlier, issues that occurred in 2012 and 2013, and most recently as July of 2013. And one of the things that I haven't an answer for, and one of the things we need probably to consider is, yes, we've got these accounts here. No, we don't have an auditor like we could be sending out there regularly. We don't have that available to us. We do have other people who are still clients of this particular firm, and their particular issues going forward are something we need to consider based on what we have before you on.
I wanted to ask Mr. Harvey that question. Do you have a sense of how much money Griffey and Associates is holding that belongs to other people at this point?
I do not. If they have a property owner, according to the representation that I'm making, which is a representation that Griffey is making through me, if you have a piece of property there and they get a check in July, they're going to account for that properly. They're going to make that payment, even if they have an arrearage back to that same property owner. We're trying to make sure we do it right. I don't know. Again, and I want to emphasize this, I never believed, and I don't think anyone would hold me to the task, to really show you how our accounts became so off track today. I really can't answer that question. This was an emergency hearing. Come down if you guys want to explain anything and why, because it's a summary suspension of your license. So the first method was, if someone says you owe us money, we haven't been getting our check, I asked Griffey to try to reconcile and figure out how much we owe them, how we made the mistake, why we made the mistake, that sort of thing. But I don't think they have ready cash to pay these amounts. Or my representation would be, let's try to go to that next step, which is payment.
My concern would be that cash is coming in now, that came in July, for instance, doesn't and continues to not be dispersed properly.
My representation to you is that I understood Griffey accounted for everything through June. So a June net payment, whatever a person would be entitled to in June, would be a July payment. I haven't seen these other complaints, but if someone says in July I should have gotten a check, that's not for July rent. That would be for an August check would reflect the July net proceeds. And so Mr. Griffey has told me that his office is telling people, if you're still here, that we're going to account for you properly after that date. Again, I don't have these figures, but there aren't many people who are staying.
I can understand that, but I can't. If all of a sudden they're going to start doing it right, I mean, that's the idea you've got to sell to us, I think.
Well, let me tell you the idea I would like to sell to you is we had to come down here today, and we were treated fairly and properly by your staff. There's a summary judgment proceeding, and they noticed us up, and that's the law, and so we're down here. If we hadn't been called to come down here today with hopefully good answers to a bad set of questions, we wouldn't be down here today. We'd be doing what I've just told you, which is talking to a real estate broker up there in Clarksville and saying, we're going to close down. Would you take this book of business? And that would produce a Griffey and Associate asset, possibly. And then one of the real estate agents in Tennessee who has a license and can do the work would be taking it over. If we could have made that transfer yesterday, then we probably could have made that transfer, but it takes a little time for him to look at the book of business and decide what he wants to do. But I can tell you that we're looking for an orderly winding down process. And if the phone wasn't answered, I can only tell you I don't work at Griffey & Associates, but I can tell you that the majority of the phone calls have been about people who are looking for monthly checks, and I'll tell you where the phone is getting answered is over at my office.
You know, when you hang your shingle out as a real estate agent, you have a duty to the public saying, I will always take care of your monies. And he hasn't done that, and I think our staff is well-founded in wanting to suspend his license till he can get his act together. And I would vote that we do that, because $200,000 is a lot of money to go unaccounted for. And I know you said that's a stretching it, but if it's $10, it's too much for this body to accept in handing other people's money.
Well, I wish it were 10 instead of 200, but I understand your point. I just want to accurately give you information. And I will say this: having the circumstances being what they are speaks for itself. I'm not here to try to imply otherwise, but I do think that there's some merit to believe that I don't know the powers of this board. But for example, when you talk about Mr. Provo taking it over, I can tell you that our hopes are to find a licensed real estate agent who has met the duties that Commissioner Collins just talked about, to come in and he makes sure nothing goes further in the red, that it is handled properly, and that might help us in some way with a more orderly liquidation process.
Perceive bankruptcy in the future of his firm?
No, I mean that's a possibility. His firm is an LLC. He is, I'm not really sure, but I think he's the sole interest holder of the LLC, and I have talked to him about the spin-off of all of this. But again, we're here today because this staff has the power to do it, called us down here, and I don't know that a decision's been made on bankruptcy, but it's not been filed yet.
Harvey, you keep indicating that someone is managing these accounts, looking after them. Is it somebody besides this individual?
Oh, well, these accounts are still at Griffey & Associates. I realize you're in a summary suspension, but I don't know who the staff people are. But yes, he has a small staff, and it's the same office, it's the same group that apparently has an account that's out of balance like this.
Those are probably the folks that got him in trouble instead of himself.
Again,
he turned it over to somebody else, and the money got away, but that's his responsibility because the buck stops with the broker, principal broker.
What leads to the conclusion, it may be exactly on point. I just always want to know that I'm going to tell you the things I know pretty certain. I'm going to tell you the things that I don't know, but certainly I think that when I tell you who did reconcile that book was his in-house people. Who did say they're going to turn that over would be he and his in-house people, yes.
What deeply concerns me, the money, the past money's already happened, and recovering that. Of course, if he's got assets, but he can bankrupt an LLC, and those other things are not, he doesn't have to pay anybody. But he still represents, you say, 25 or 50 folks. Have those folks been notified that there's a problem?
I did say that, but I was asked to try to offer my best opinion from my looking at it.
It doesn't matter whether it's 2 or 40 or 60.
Yeah. I really don't know whether a property owner who has a management agreement with him that hasn't complained and hasn't called and hasn't been identified by us has been notified that we've got a problem with another property, like, for example, Mr. Wild, who has complained. I do not know that.
How long have you been retained? How long have you been working with Mr. Griffey?
When one of the first lawsuits was filed, I was retained to represent him for a period of time, and that would have been probably early in the year this year. Please don't hold me to that exactly. A few months ago. And then that lawsuit status changed, and another attorney was handling that. So there was a break in representation.
So you were just handling the lawsuits, but you seem to have recently gotten into the workings of the business now.
About 3 weeks ago.
And do you have any idea how many employees he has?
No, not really. I
Okay,
know he
so-
has at least 2 that work there.
Okay.
But he could have 5.
And does he have an outside accounting firm, or is this all in inside? Is the way it sounds?
All of his property management was handled inside.
Has an outside accounting firm been called in?
The answer is, in regard to the first claim that I mentioned earlier, yes, I think they're looking at that first claim. It started earlier, it was the first one, and I think an outside accounting group is working, but I'd like for you to
with one.
understand that's not my first-hand knowledge. I didn't retain that group, but I believe that's true.
And Ms. Ryan, would you clarify for me, if we were to suspend his license, exactly what would be different from here forward?
Well, then,
What could he do? What could he not do?
well, there are two licenses involved.
Right. We've
Griffey and
got
Associates and Mr. Griffey. If Mr. Griffey's license is suspended, he can do none of the functions of a licensee, none of them. If the business is also suspended, they can't go forward with any of the functions of the persons that are still in contract.
so they would
with
have
them.
to stop answering the telephone. They'd have to stop
They would
collecting
have-
rents.
they
They'd
would
have to stop reconciling books.
They would have to stop.
if they did.
Well, I'm not saying about reconciling books, but I'm saying that the activities as outlined in the statute they couldn't do. That is, the rent collecting, negotiating rents, those kind of activities they could not be doing. Even managing the property they could not be doing.
You say he does not have an escrow account, and that has been verified?
No, it has not been verified.
Okay.
But let me go back, and I wanted to clear up something. In 2011, I indicated to you that there was a consent order, and the facts that were agreed to in that consent order were 5 instances of insufficient fund checks, and an audit in 2011 from one of our auditors found that the escrow account, so at least in 2011 there was an escrow account, but did find that that escrow account in 2011 was $161,101 short.
Can I say this to you? I've made several admissions here that all choked on. I would not make the admission to you that the representation that the hearsay comment that he's admitted he doesn't have an escrow account. I don't think that.
Okay.
He's
Well,
indicated otherwise.
I'm just not sure.
If we were,
I want to figure out the best way to protect the public.
Right.
And if we were to take away his personal license and possibly leave his business license where he can wind things up, I'm not. I want to protect the public. Is what
I
I'm
agree.
looking at.
And I will tell you that I think the business could continue, but again, there'd have to be somebody in charge, and you can't place somebody in that. We are not in the position, unlike other business where sometimes they're in receiverships and we can go forward. We cannot do that. But the only way the business could go forward is if it were not only properly licensed, but had the people necessary to do the job for that license, which would mean there would have to be somebody in place. But you are also right in that if the business stopped, there are the entities, the individual entities out there that are doing business that would be affected as well.
How many other licensed people are in that firm? Just one?
The reason I've represented to you that we're talking with a real estate agent who's properly licensed to do property management, does property management, is solely mirroring the comment you're making, Commissioner Haynes, and that is that if we're trying just to make sure there is no future harm and we're acknowledging past harm, at least in some cases we may disagree on the amount, and we're looking at marshaling assets, I don't know that we create an immediate risk of harm to the public that would cause you to be benefited by shutting us down. As a punitive measure, whether he should or whether, just based upon this information, whether you believe he should be shut down, I don't know that there's anything else that does other than closes the telephone line where they're going to get a phone call to Griffey and a phone call to me.
I'm not even really sure that it does that, though. Maybe it's supposed to.
I'll look real carefully at what happens, but if you suspend his license, if you suspend the license of the company and his license, we're going to make sure we don't practice without a license. So we're going to stop doing all those things that you shouldn't do if you don't have an active license.
I think you'll agree with us that in 2011, if we had taken this license in, this wouldn't be coming up today.
Well, lots of...
You agree with me on that?
Well, the yes, the logic of passing of time is true, but respectfully, lots of things could have brought us not here today, and I think it's reasonable to say to you, please recall, Mr. Griffey's not here to say here's what happened or here's what my health issue was, because today's not a full hearing on how this happened. If there are 5 bad checks, we might all suppose that couldn't happen if you're doing your job right. But if he's got an explanation, then he ought to be able to do that. And this hearing is very important and very powerful, but I understand limited to a summary suspension. And I'm saying to you that here's what we're stepping up and telling you is the current status. If you summarily suspend us, I think some of the things we've been doing, which are beneficial to the public, probably will be curtailed, and that's certainly no threat. I'm just saying if we look at it and say nobody's got a license up there, we can't collect any further rents, then we're going to have to start notifying the people we have.
Let me address that, just so, and Julie reminded me of this, we do have a new rule on the death or extended absence of a principal broker. The commission must be notified within 10 days, or unexplained absence. That would not be the case here, but the commission may, in its discretion, based on the merits and circumstances of each case, permit a real estate firm to continue operating without a principal broker for a period of time not to exceed 30 days from the date of death, resignation, termination, or incapacity, subject to conditions imposed by the commission. If, within the aforementioned 30-day period, a real estate firm contacts the commission demonstrating compliance with their initial approved plan and circumstances which require additional time to continue operating without a principal broker, the executive director shall have the authority to grant a 30-day extension to the period originally allowed by the commission. In the event that a 30-day extension is granted, a new principal broker must be in place no later than the 61st day from the date of death, resignation, termination, or incapacity. So back to the question that you had. We cannot put a principal broker in place. We can't do anything. We can't take over the business. But if this commission suspends Mr. Griffey's license, the business could, with your approval, be granted a 30-day extension to get a principal broker with conditions that you place on that business. At the end of the 30 days, if a principal broker were not in place, the conditions and terms would be presented to the executive director, who could then determine another 30-day period would be warranted. So in essence, if this commission determines today to suspend the one license but not the other, I would suggest that you would do it considering this rule and make conditions for that rule, understanding that at the most there would be a 60-day period without a principal broker, but a principal broker would have to be in place sometime.
I was going.
I have a couple more questions that concern me. Mr. Harvey, you made the comment that if they write checks today in August, that's going to be for the month of July.
That's what I understand. I want you to remember that that's what I understand, yes.
Okay. I have a property management firm in my office. We collect rents every month, but by the 15th of that same month, my owners have their checks. So why would this firm hold them for a full 30 days before they're dispersing funds?
Let me be very clear about one thing. I've never looked at their property management contract and whether it says they'll do it by the 15th or do it by the 20th or do it by the 30th. I just understood, and I think this is really important too. I was trying to say to you that I do understand they've represented to me they've cleared it through June, and that I have not seen these July complaints yet. So my understanding is that you don't, on the spot, you don't pay immediately. Your contracts may say 15 days. I have never looked at the Griffey contracts to see what they say. I just was offering you the suggestion that these July complaints would not necessarily, see, I don't even know when they were made, but these July complaints would not be a valid July complaint under what I'm telling you. I understand their efforts to be could be made because we didn't get something in June, and I'm acknowledging to you we've reconciled the books up through June. We had to kind of get a day.
Okay, and you also, when one of the commissioners at the other end of the table asked about the staff, indicated that we still have the same staff in place.
Indicate to you that I have no knowledge of the staff, and I will tell you that I don't know if it's changed one person. I don't know if they've added one, replaced one, or one has come and gone. So I think there are 2 or 3 people. I've been there. I've talked to 2 or 3 of those people, but I mean, my representation to you is I don't know if it's the same staff, and I sure don't know it's changed, and I really don't know how big it is, but it's not too big.
Ms. Ryan, if we vote today to suspend these licenses of Mr. Griffey and of the farm, that does not prohibit him from closing that business down, liquidating his assets, and paying these people for what he owes in the past, correct? It just prohibits him from continuing to do business from today forward.
That's correct, and that would prohibit him from then addressing those other people that still have their contract with them.
They would have to transfer to some other farm.
But it doesn't prohibit him from selling his business, the 20 or 25, whatever it is, to another firm either.
No, it does not.
I do think, though, recognizing what arguably might be an easier transition from this one's closed down and I've gotten a letter to this one is active and we're transferring it to this company. I think there's some asset value there, and I think it's orderly. And again, if we assume the worst if we all assume the worst conclusion from all of this, I don't know that there's any real evidence that Griffey and Associates would be at all motivated not to account properly from that date forward, even if they've transgressed for 6 months before. If I've told you that Mr. Griffey's indicated to me that he doesn't plan to try to preserve his ability to have a real estate license after he's able to close this down.
You're just trying to preserve value in a business that's open versus a business that's not.
That's what my client has told me are our intentions, and I've outlined how we're doing that. And I can tell you, with the people I talked to, and I read you their names, those are the representations I made to them.
Harvey, and I realize you only speaking for your client. Are you telling me that your client has indicated to you that he intends to cease operations?
Yes.
As quick as he can?
Yeah, I think so. I think he's
I'm more concerned about the clients he still has.
I see that as a different category, and I see, is it the same staff, and if it was sloppy bookkeeping, will it happen again? That's a different category.
It's not going to change.
That could, I think that for my purposes, I can't offer you any different facts that make a difference there, but I can tell you that from a standpoint of emergency harm to the public, I don't know that if we are able to find a broker who is licensed by the state of Tennessee, governed, and meets all the duties of the real estate law, then if he takes it over, and my representation to you is we're attempting to do that. But we've got to find somebody too, and we're talking with one individual in particular.
Let me stop you right there for just a minute. Are you talking about trying to bring in another broker into this firm,
Oh,
or liquidate this business to another firm and get it completely out?
Liquidate.
Okay. Okay.
Now,
Yeah.
now I want to be honest with you, because I can only tell you about Tim Harvey, but that's what my client has told me is his plan, and everything I've been doing is in line with that.
I have anything to do with it. I'm gonna help him get out of business here in a minute.
So, could I, Robin, ask, that $160,000 shortage in the escrow account was in 2011,
That's correct.
and subsequent to the finding that shortage, was it corrected, do you know? I mean, do we go back and find out, or has it been upside down for years?
I do not know. Do you know, Eve, if an auditor went out after that?
The auditor went out several times, like several times after that, and would continue to check on it. Prior to that, those sets of complaints in 2011, he didn't have a shortage of any substantial amount. After that, as I say, the auditor went out several times. It was down at one point well below $100,000, and then I let me tell you all. I mean, then I understand that he lost a number of properties, and Mr. Harvey may know this better than I do. I understand that from the auditor that he lost a number of properties, and that sort of, I guess, was one of the triggering factors that occurred. If that answers your question, I don't know if that answers your question or not.
I'm just, there's a pattern. It's just that it hadn't started in the last 6 or 8 months, it sounds like to me.
Well, now, again, please let me remind you that Mr. Griffey's told me he's got significant health problems. Now, I'm not a doctor, but they include the vascular type of problems that affect your ability to recollect and think and cogitate. And so before you really leap to what might be a logical conclusion, but a logical conclusion without knowing these other facts, he told me, he was at the hospital yesterday, he told me he's going to be at the neurologist today, he told me he's had symptoms and problems for some time. So I only speak to say we may find out that it's happening not because it was a continuing problem without at least some information that maybe he's got a health problem. And he did tell me, too, that they suspicioned he had a stroke. But, again, I'm no doctor.
Mr. Harvey, how old is Mr. Griffey? How old a gentleman is he?
Oh, I'm 55. I would say he's in my age group. But if I'm off 10 years, don't blame me.
I'm prepared to make a motion.
Let me add just a couple more pieces of information you should know that are sort of pertinent to the. And a summary suspension is a temporary, it's an immediate thing based on the public health, safety, and welfare. Following a summary suspension, there must be adequate time, quickly, for a full formal hearing. A formal hearing can be heard on August 27th if a summary suspension is determined, but you would all have to agree to allow that formal hearing to go forward before an administrative law judge unless all of you would agree to do an emergency meeting and come back and have that hearing. That's the first date. The next date we do have available before all of you is September 12th. I waited. I'm going to lose that date shortly because it's the 8th of August. If I don't file something too soon, we will not have a hearing on that date. But because of this, we did not file. So that date is preserved in case you wanted to go forward on a formal hearing.
Is that our regular meeting?
That's your regular meeting date. The next dates that would not be available would not be until November, and again, those would be for an ALJ alone. And understand that the respondent would have an opportunity to be there, and if the date weren't good for that respondent, and then they weren't acceptable, then we couldn't do it either. And then the summary suspension would remain in place.
But his attorney said he was thinking about quitting anyway.
I understand.
He may not even want to come to
It may not.
That's
I know.
If you'll let me respond, I think if you summarily suspend his license and the company's license, we'll be moving slower rather than faster. If you don't summarily suspend it, and we can try to get all the current business transferred out and try to turn all these claims into what we admit and what we don't admit and so forth, then sure, by September 15th or whatever date she said, we may not be trying to use a license.
Mr. Harvey, I can't see how this commission could continue to let this man operate when we're aware of the circumstances we have. That's not what we were appointed for. We were appointed to protect the public.
Let me assure you that I'm not a voting member of the commission, and I'm not trying to tell anybody what's their only choice or best choice or clear choice. You gentlemen and ladies are encumbered with that responsibility, and I'm just trying to tell you that I am retained to try to close this down, and Mr. Griffey is seeking medical care, and I think the question is, well, do you really want to summarily close him down, or could we be closed in a circumstance that gives us 30 days to find a broker who is one of those fine real estate agents that you have confidence in, that's going to just at least organize who may be owed money and how much they're owed and maintain their properties.
Mr. Harvey, I sincerely believe everything you're telling me, and that you're doing your job, and that I have the confidence that you've told me everything, and it's like you said. But your client can fire you today.
Well, I'd like to say otherwise, but you're exactly right.
And then I'm taking what you tell me, and I believe you. I cannot. Mr. Char, you make your motion, and then I may want to amend it. Go ahead.
I need to say one more thing, and Mr. Green correctly made sure I advised you that if you could also decide not to summary suspend at all, and at that point these matters would go into the formal hearing process and we'd send it for hearing at a later date. But those are the options. There's 2 licenses. There you can do the suspension for both, you can do the suspension for one. If you choose to do the suspension for the one and not the business, you can take advantage of your rule and put some conditions in place with the understanding that they have 30 days to get a new principal broker. You can suspend them both. If you suspend them both on the summary basis, then we will have to have a hearing. And the dates that I gave you are the hearing dates available.
Will we still have to have a hearing?
Yes, unless it comes to the point where things are resolved and he agrees.
They're
that then-
resolved, okay.
But yes, he would have that opportunity as well. If he agrees not to pursue a immediate hearing on the one, then no, you don't have to do that immediately. But that is up to the respondent at that point. The respondent could also agree to do an agreed suspension without a summary suspension, but that would have to be their agreement.
I guess my concern with leaving the company open and giving them 30 days to close things out is that you still have the same staff in place, and I'm not sure that what money's there's not going to go away anyway. And so I'm making a motion that we summarily suspend both licenses.
Heard the motion. Do I hear a second?
I'll second it. for discussion.
Have a motion to summarily suspend both the broker's license and the firm license.
Mr. Chairman, I'd ask that you divide the question. We'll get to the vote.
Say again.
I'd like to have a separate vote on each license. Just divide the question.
The motion is for both licenses. Would you like to amend to the motion?
I'm just asking that a question, since it's two questions in one motion, that it be divided.
To be divided?
Yep.
You like to make a motion?
No, not yet. I'm just asking, we can vote on each license that way.
I'm gonna request the same thing. I want,
Y'all gonna have to change the motion. You're gonna have to amend the motion.
I can ask to divide the question.
I ain't asked to divide the question because I didn't make two separate motions. I made one motion.
Motion includes two licenses, so I can divide that.
Okay.
But you get a rule on that, Chair. If you don't like it, you can tell me no.
I'm not looking at Robert's Rules of Order. Don't have a copy of it.
It's real simple. All you got to do is make another motion.
Why don't you just amend it, make an amendment that we vote on each license?
That's what I just did, by asking to divide the question. That's the motion.
Okay.
I'll second that. If that's your motion, I'll second it.
Okay, we got a motion on the floor to divide, to amend the previous motion to be, each license to be voted on separately.
yes.
A motion and a second.
Now, before you call for the question, I want to speak to the motion. Damage is done. I can see, I can't see suspending these firm licenses today. I think you need to take out of action. Yeah. Take him out of action. If Mr. Harvey would agree to suspend him himself or take the voluntary suspension, that would be great. But he's not going to do that, and I don't think he has the authority to do that today, probably. I think that this firm needs to be liquidated. If I thought that he was going to try to continue to operate, then I would be for the suspension of both licenses today. I think that it needs to be an orderly matter, that the way that you liquidate it, that I would ask if you continue to operate it and put another licensee in place, then I'm going to, the next time we meet, we'll send an investigator up there and start all over again.
Any other discussion on the motion to divide the licenses? Vote on each one individually. Hearing none, all in favor say aye for the motion to divide the licenses and vote individually. Say aye.
Aye.
Opposed, no. Motion carries unanimously. We'll vote on each license individually. And license number 6984 is the broker's license for Gary M. Griffey. All in favor of summarily suspending that license, say aye. Aye. Voted. The vote is unanimous. We're now voting on the firm license of Griffey and Associates, number 11985. All in favor of suspension of summarily suspending that license, say aye.
Aye.
No.
All.
Oh, wait a minute, I'm going to back up.
You're gonna have to do roll call.
We'll do it. Ms. Eve, call the roll.
Can I ask a question?
You can ask two questions.
I just want to ask one. Wendell indicated 30 days.
That's 30 days.
It's 30. It's
Well,
in the,
but it can be extended to 60.
Okay.
Well, that's up to Eve.
Yeah.
Yeah,
It
but
can't be up
they've
to-
got 30 days, or the executive director's got to agree to extend it for an additional 30 days. But they've got 30 days to liquidate.
Call the roll, Ms. Maxwell, on the suspension of Griffey and Associates
On
first
Robbins.
license number 11985.
Alexander,
I vote no, not to suspend it.
not to suspend the firm license. Collins?
No.
Tachara?
Yes.
Grease?
Nope.
Flitcroft absent. Haynes?
No.
McMullen absent. Stevenson?
No.
There are 5 noes and 1 yes.
Motion fails. He still has his firm license, but his broker's license number 6984 has been summarily suspended.
Mr. Harvey, just one follow-up to this. So he's the sole owner of the LLC that owns the firm.
I made that representation to you that I believed he was.
Well, which, if it is true, I mean, still gives him a lot of, it could put him in a position to be running that company as owner, not as broker. And I would hope you would advise him that our intent is to try to help him orderly shut this thing down and not to find some charade to keep it going in a different format.
What I told you his intent was to find somebody who would buy his business and we could close the doors, liquidate the assets, and try to pay the
May
rearage
not
we
have
owe.
anything to buy.
Reality being what it is, but we need to try to find someone because we had hoped to find someone because it would create some value.
Like an upfront guy. Would you
Try to
keep
be,
us
sir.
apprised of what's going on?
You know, I'm an upfront guy, but I am a lawyer, and we have to honor attorney-client confidentiality and privileges.
Anything unconfidential.
That's right. To the extent that I can relate to you information, and the extent that it is within the law, and I'm authorized to do so by my client, which I was authorized to come here today and lay a lot of cards on the table. I'm happy to keep you advised as I am allowed under applicable law, but I hope it doesn't take long.
I was going to say, you don't have to notify us, just notify either Ms. Ryan or Ms. Maxwell.
Commissioners, I will also tell you that I just spoke with him about a hearing date for Mr. Griffey individually, and he has, depending on Mr. Griffey's health, agreed to the September 12th date with it may be all resolved by then, and it may not be an issue, but I will draft it and get it to him. If the health does not permit him, then we will not have the hearing on that date, but it is by agreement. Is that right?
Yes. I mean, again, subject to his medical condition that I've told you what I know about.
Now, I think that concludes this proceeding, Ms. Ryan.
Well, except, let me ask you a question. You have voted not to suspend the license of the firm, and you realize in suspending the license of Mr. Griffey that this business no longer has a principal broker. Are there any terms and conditions that this commission, in understanding the incapacity of the principal broker, are there any terms and conditions this commission would like to impose on the continuation for the 30 days without a principal broker?
I'd like to see them continue with the oversight of their attorney
Well,
for 30 days.
You can't do that.
Well, that's what I'd like to see.
Well, I'd like to see it too, because he seems to be up front. I agree.
Ms. Ryan,
Yes, sir.
since you represent the state, a.k.a. us, what would you recommend that we do?
Well, I actually would turn that over to Miss Maxwell as to what kind of things. I mean, I don't know necessarily that there are any conditions. We know the issue here is that Mr. Griffey will not have a license, and that they can, at this point, based on the notification they had, the incapacity of the principal broker, continue for 30 days without a principal broker. I don't know. I'm going to let Eve address. Go ahead.
I just recently rewrote all the list of things that would be beneficial for a firm to include in their plan of continuation, and it's on our website. There's a notification, and then there's a list of, as I say, a pretty comprehensive list of items that should be included or should be considered to be included. Like who's going to be running the firm on the day-to-day basis, that they can't take in new business, who's going to handle the escrow, who's going to handle any payments that have to be made, who's going to check and make sure that, say, repair bills that come in are accurate and are properly attributed to the correct accounts and the correct houses or properties. So there's a pretty long list of things that I can get him a
I will- I
copy,
will-
Mr.
I will be
Harvey a
happy.
copy, and then
Yes.
let Robin and Julie look at it and him look at it and see if there are other items that might be necessary.
I just said I would email that to him
Yeah.
today.
Thank you.
Ms. Maxwell, in that, this firm cannot take on any new business.
That's correct. That's one of the things that's in there as well, that they can't take on new business.
However, if they put another principal broker in place, then they can continue to do business and take on new business?
They put another principal broker in place, then yes, they
Yes.
can.
They can just up and running and keep
Right.
going just like
So
today.
So the terms are, so we understand that while there is no principal broker in place, no new business can be done.
Let me say this. It's hard for me to agree to anything that I haven't had a chance to talk with my client about. Again, I have clearly represented to you that it's a winding down process that we intend. So if we have a principal broker in place, if that happens, I'll tell you that I'll try to talk to this staff and have an outline of what that plan is, because I think it'll be directly associated with the winding down process, if anything.
Well, I think the law states that we can put conditions on it, whether you agree to them or not. And I think the condition is no new business, and you follow Eve's outline. That's a condition that we're putting on him. So I don't know if the rest of the commissioners agree with me or not. I mean, it doesn't matter if he agrees or not. That's just a condition we're putting on it.
Outline, and it's either approved or not approved. So up to them to say, here's how we're going to operate, and then that's what's approved.
But I would like to put the condition on no new business, period, and then the rest of it that y'all can work out.
There is a condition that is inherent in the law. Without a principal broker in place, they cannot do new business.
Okay.
It would be a violation of the law if they did.
Well, you wanted conditions, and that's definitely...
Okay, well, but that's
Okay, that's already there.
spelled out.
But they can put a new broker in place tomorrow
And they could.
take on new business.
They
Well, could that be one of our conditions, even if they put
Well, that-
in a new broker in place?
I don't
We
think so.
can't do that.
I don't think you could,
Okay.
because you haven't made a finding. If you wanted to make that kind of finding, you may be able to do that in the future if you authorize a formal hearing on the business itself.
Okay.
And I'm going to ask that if because you did not suspend that, are you authorizing a formal hearing? I'm asking to authorize a formal hearing on the business itself, and that'll be sometime in the future.
Yes,
Yes.
that's a protection, that's a stopgap.
Yes.
I would
I
move-
don't anticipate that will be until next year, so probably it will be a moot point. My hope is that
We
it's
hope
a
it
moot
is.
point.
This is simply, Mr. Harvey, to be sure that nobody goes away.
No, you were right. I mean, I can only act in the role I have, which is attorney and advisor.
I'd move, Mr. Chairman, that we schedule a formal hearing on the
Authorize
business.
it.
Authorize it.
Yes.
Yes.
Please.
Well, September 12th is going to be
Just
the
for
broker.
Mr. Griffey individually. The firm itself would be sometime later in the future, and as I
Do we not do them
indicated-
together?
Don't want to. I don't want to.
No,
don't want to.
no, there,
Yes.
you don't, I
Okay.
would not
Okay.
suggest pursuing together, because the issue for September 12th will be the continuation or other action against Mr. Griffey individually.
Okay.
Okay, anything else? Mr. Harvey, do you have anything else to add?
Only my thanks for allowing me to speak to you. Thank you very much.
Ms. Ryan?
Have a safe trip back.
I think then,
Wait a minute, what? Yeah, you did make a motion.
there's nothing died on the floor. We're going to have a formal hearing on September the
Yeah, this is
12th.
he made a motion on the business.
I'll
side.
second
Thank you.
Commissioner Alexander's motion.
To authorize a formal hearing in the future on Griffey.
At a future date. We have a motion on the floor and a second. Motion made by Commissioner Alexander, second by Commissioner DeChar, that we authorize a formal hearing at some point in the future on the firm of Mr. Griffey, which is number 11985. Any discussion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carries unanimously. Anything else, Ms. Maxwell, pertaining to this informal conference?
That's it.
then I,
Well, no, we're not done yet.
we're not done yet?
No, we're done with the informal conference portion of it.
Yeah, so
but
I
you
know.
are not finished.
Oh, I know, we're not finished for the, I'm aware of that. We got Mr. Mark Green sitting back here, who's, I understand, wants to say a few words. Wait, now let's take a real quick break.
Thank you, Mark.
Call this commission meeting back into session, and next on our agenda is our attorney, Mr. Mark Green.
Prodigal returns.
He's back. We have been missing you.
I appreciate it. This will be just this will be brief, I hope. Back in February of 2012, the commission had a hearing regarding a respondent named Donna Bobo. Ms. Bobo was charged with Ms. Ryan. What was the specific disloyalty? I waited till you put food in your mouth. Disloyalty to client, and there was 13 separate findings that the commission made regarding Ms. Bobo, and voted to revoke her license, and also assessed a $5,000 civil penalty and cost of approximately $2,100. Ms. Bobo appealed the matter to the Chancery Court of Davidson County. It went to Chancellor McCoy in Part 2 of the Davidson County Chancery Court. 2 days ago, we received Chancellor's memorandum and order, and Chancellor McCoy vacated the Commission's revocation order, vacated the civil penalty, and assessed the cost against the Commission. We are reviewing this order. We are talking with the Attorney General's office. We have been in meetings with the General Counsel, Ms. Nancy Jones, who is my boss. We are going through line by line this order in order to give you a recommendation as to what and how to proceed legally next. With all that said, the court ruled that the order, the evidence did not back up the findings, and it was arbitrary and capricious. That was her finding. We don't agree with that. Legally, we don't agree with that. And so we are going to be formulating a recommendation to you. The deadline to file the appeal is September the 3rd, 2013. What we will be doing, because obviously you won't meet before then, and it will give us some time to continue to talk to the Attorney General's office and formulate a recommendation to you, is we are going to ask Ms. Maxwell and Ms. Kropp to arrange a telephonic conference through the public necessity rule and have all the commissions call in so we can go over this in detail and give you our recommendation. We will give you as much notice. Obviously, it has to be done before September 3rd. And so as soon as we are through, and when I say we, I mean everybody in the legal chain up to the General Counsel has reviewed this, we will come together and give you what our recommendation is as far as legally how you should proceed. The major concern that we have is a procedural matter. The judge took issue with some of the procedures that we do regarding verified complaints and the Commission's ability to proceed on its own motion when a complainant all of a sudden becomes uncooperative or doesn't participate or doesn't show up for the hearing in order to verify what the information that was in there. We argue that the statute is clear that this Commission has the ability to continue and go on and hold a hearing. Chancellor McCoy took some issue with that. So it's not just this ruling, it's the procedural implications that we're looking at that's the major concern. And so I just wanted to take a few minutes to give you some information about that. I know you're going to have questions about it. We're still reviewing it, and so forgive me if I'm not specifically able to address each and every question. I promise you we will, and that the whole legal staff is looking at this, from Julie to Robin to me to the other chief counsel, Michael Driver, to Nancy Jones, our general counsel in the commissioner's office. So with that, that was the information I wanted to give to you today so that you would be aware of that going on.
Were we ordered to grant her a license as well?
It just completely revoked what the commission did, so that gives her a license back. That gives her a license back.
First time that's ever happened.
It is the first time that this specific type of order, being that detailed regarding the procedure that we do every day, has been questioned. Yes.
When do you envision having something in place to go ahead and schedule a telephonic?
I would say we would be, today is Thursday, I would say by next week we'll have a date. We have to give a minimum of 2 days' notice to the public that this is going to happen. So I'm anticipating, by next week we'll have a date definite, and that would probably be the week after that, if not by the end of next week.
So what's the procedure? The public can listen to our deliberation?
Well,
also, they could call in?
The public has to know about it, but I don't know that they'll have a call-in number. I'm not really sure.
One time before, when we had a telephonic discussion, they could call in.
Yeah.
We didn't have any callers, but they could have called in, or they could have come to the room and listened to the conversation.
Just have to give the public notice that it's being discussed.
I wondered how that happened, because we haven't done that.
Never done one, so I'm not 100% sure.
Okay. Well, we want to make sure we do it right,
Absolutely.
obviously. Okay.
We did it one time before when I think there was an issue before the commission whether or not the commission would suspend a final order that it had issued, and the individual was going to appeal it. And we had a telephonic conference, and it was set up sort of like we do our bridge lines in here, where each individual commissioner calls a number, and then you're on the speakerphone, and there's a discussion, and each of you can hear the other person. So it's kind of much similar to what you've seen in here, where we had someone testify over the
Conference calls.
Yeah, but so
Several
that operates the
times
same
but
way.
not with this.
Yeah, and as I said, we didn't have any public come last time.
I assume if we wanted to review that case, we would have privilege to that.
Absolutely. I will, if you would like me to
I don't,
give that to you.
today I can't even, I don't even recall the details of it. And send me the case, I won't look at it again.
No.
If that's permissible.
I think it's permissible to review.
We did it. I guess we'll see what we
it is
did.
permissible.
I guess we got a
We could
copy of
do
what we
it
did.
from our minutes, if from nothing else,
No.
but the consent order,
It's
public record.
yeah.
So, yeah, I'll forward.
Julie, what do
Here's
you
what I'll
have
do.
copies of?
I'll forward all of the information. I'll forward the order of the judge and the memorandum of the judge, and then if any commissioner would like to review any of the record, I'll be happy to forward that as well. Right. I think we can get our full file and transcript and
She did not show.
yeah. Well,
Robin,
She was present with an attorney.
the complainant didn't come.
The person that initiated the process.
we did a teleconference with her, didn't we?
Yeah, go ahead. You can.
No, she decided
That's the one that backed out at the last minute.
at the last minute, she was in California, was going to appear
yeah.
by telephone, and decided at the last minute she wouldn't testify.
I will forward all information for your review. I would just ask that you not discuss it among each other until we're all together. So,
Anybody have any other questions of Mr. Green pertaining to this issue that he's been telling us about? If not, then is that everything you have for us, Mark?
that is all, Mr. Chairman.
Okay, thank you. It's good to see you.
Thank you. Appreciate it.
It's my participation today as well. Thank you.
Welcome.
It includes my participation as well, too.
Robin, did Julie have some of those documents for us already?
Yes. Mark?
Yeah, you can go ahead and give you the judge's memorandum in order to review.
That'd be great. The more we got ahead of time, the memories can get jogged a little bit, maybe.
This meeting, for all you attendees out there, this meeting is about to be over. We're about to wind down the last thing of this monthly Real Estate Commission meeting. Thank you. Does anybody, now we come down to the commissioner reports. Commissioner Haynes.
I got one. I'm just excited. The market is improving, and the agents are out there doing their job and enjoying what they're doing, and I want to pass that excitement on to everybody else, because you already know that, I would suspect, particularly if you're Middle Tennessee. And just do your job right.
Commissioner Alexander.
I've spoken enough for the last 2 days. I don't have anything.
Commissioner Grease.
I have no report other than to acknowledge you did another adequate job as chairman this month.
Thank you, Commissioner. Commissioner Collins.
Hope everybody has a safe trip home.
Commissioner DeShara.
Everybody drive safe, and glad you were here. Hope you learned something today and yesterday.
I concur with what Commissioner DeShara. We hope you've learned something by being here that you can take back to your individual offices and share it with them, and have a safe trip home and go forth and sell a lot of real estate. Julie, you did well. Ms. Maxwell? Yes. This meeting is adjourned.